Monica, do you fear employees talking about you in the workplace? What if they did it in a different language?
That's next on Employment Law After Hours.
So on this episode of Employment Law After Hours, we're going to discuss employer policies that require English-only speaking in the workplace. Hence the reason for that intro. Most of these policies come about when managers and supervisors disfavor or otherwise get upset when employees are speaking in a separate language. Those supervising managers, typically without any reason, typically fear that those employees are talking about them behind their backs. So today on Employment Law After Hours, we're going to discuss the limitations of English-only workplace policies. But first, I'm going to turn over to Monica for a quick disclaimer.
All right, so if you've watched any of our episodes, you know that Brian and I are both employment attorneys out of Akron, Ohio, but we're not your attorneys yet. So before you rely on anything that you hear in this video, make sure that you read that disclaimer below and reach out to us if you have any questions. All right, so as Brian was saying, there are some laws that are implicated when employers mandate that employees speak English in the workplace and limit the ability to speak other languages. So we're going to start with Brian going over some of those laws.
Sure. So essentially, as most of you know, Title VII prohibits discrimination based on national origin. Obviously, on its face, that doesn't say, hey, you can't create English-only workplace policies.
Right.
However, courts have interpreted that to mean that you cannot implement an English-only workplace policy without violating Title VII unless you could prove business necessity, which we will get into. So creating an English-only workplace policy on its face, and that's considered as by the EEOC, as we'll dive into, is considered discrimination based on national origin. So to dive into the specifics of the rule regarding English-only workplace policies, I'm going to turn it over to Monica, who's actually going to discuss the EEOC guidance. Now, as many of you know, the EEOC guidance isn't actually law itself. However, given that the EEOC is charged with interpreting and enforcing Title VII, we really want to follow their guidance to avoid ourselves being in front of them in a court.
All right, so as Brian said, the EEOC provides guidance for employers as to when and under what circumstances they can impose English-only language in the workplace. So as we were talking about, that's only going to be under certain limited circumstances, and it's also going to be based on business necessity, which Brian will get into in just a moment. Essentially, long story short, this isn't going to be something that an employer can do at all times. It's also going to be something that an employer should include in an employee handbook, so the employees need to be on notice as to when the restrictions apply. Right. So for example, if an employer fails to notify their employees through policy or provision in the handbook or otherwise, that employer can be subject to discipline, including fines and penalties by the EEOC. So I'm going to turn it over to Brian to discuss what business necessity is.
Sure. So essentially, the EEOC says that business necessity means circumstances in the workplace where it would be imperative to the success or to address emergency type situations in the workplace. So the quick example that comes to mind is like a hospital emergency room. You don't want the doctor speaking a foreign language and the nurses speaking English. They all would need to speak the same language in order to address emergency situations. In America, that's typically going to be English that needs to be communicated in those emergency type situations.
Okay, Brian, so what about more casual conversations, workplace or break room conversations between colleagues?
Correct. So the EEOC does address that, and they say that you cannot limit situations to English only in a casual workplace setting. So as Monica just said, break rooms, lunch rooms, things of that nature where the employees otherwise socialize or congregate together and have that opportunity to gossip if that's what they're going to do. You cannot limit those situations to English only, even if the managers and supervisors unjustly believe that, they're being talked about in a foreign language.
So what happens, Brian, when an employee comes to a manager or supervisor and expresses these kind of concerns, especially if something happens in a break room or a casual conversation setting?
Great question. So if an employee is coming and saying, hey, I feel that this employee over here is speaking about me negatively in a foreign language, the employer can engage in an investigation as it would for any other type of harassment. And then that investigation could be conducted in English, assuming that the manager or supervisor conducting it, doesn't speak the language that the employee speaks. So essentially, business necessity running through these factors states, 1, communication with English-only speaking customers or colleagues. Again, if they're talking about work assignments and one worker only speaks English and the other one speaks a foreign foreign language, they can be instructed to speak English in order to keep, again, that business efficiency moving forward, getting projects done. Along those same lines, cooperative work assignments when a common language is necessary. Again, if you have a team of employees, everyone on that team speaks English, but half are speaking a foreign language, you can state, hey, when you're working on that project, on that cooperative assignment, make sure you're all speaking English so everyone's on the same page and on board to get that project done. The third main way, as we already kind of briefly touched on, is, again, emergency situations where communication in a common language would be necessary to address and otherwise rectify that emergency situation. Finally, number 4, and we're going to address this in an example, to enable an English-only speaking supervisor to monitor work performance and, again, conduct those investigations. But again, none of those factors go into addressing gossip, social communications, or otherwise just, casual communications amongst employees who may all speak the same foreign language.
Again, just tracking back to the notice requirements, because that's going to be an important thing for an employer to know regarding, how you inform your employees about their requirements, when and where they are required to speak English in the workplace. So obviously, we touched on the handbook earlier, but there are some other options. If you don't have something in your handbook now, the other option would be maybe to do a policy or a provision addition to your handbook. Reach out to counsel, ask for a handbook update.
So as Monica just said, do not be implementing English-only speaking policies without having a handbook policy addressing it. And again, although not required by the EEOC, it is a best practice that you put the business necessity reason in that policy.
Right.
Otherwise, you have no proof on paper written down why you implemented that policy. And if you just implement an English-only policy willy-nilly without going into the specifics of that policy, courts are going to scrutinize that, and they're going to dive down, and they may even get to the point where they just go ahead and assume that it was automatically discriminatory because the employer failed to address or otherwise state why they were implementing an English-only policy.
And along those same lines, Brian, when you're looking over your employee handbook or you're drafting that, it's important to note that it's probably safer to do an English-only provision rather than a ban on specific languages.
Correct. Yeah, the EEOC says do not be banishing, for example, Spanish only in the workplace.
Right.
It needs to be speak English only in these circumstances, not never speak Spanish or don't speak Spanish in these circumstances. Again, tie it back to English only in these cases. So that's all we got for you today on Employment Law After Hours. Don't forget to hit that subscribe button. That way you don't miss out on our weekly employment law updates, which, as you all know, are changing all the time. So it's important that you stay on top of these changes. We'll see you next time.
See ya.